Very good evening to all of you, friends. A very good evening to all of you. Welcome to the important Supreme Court judgments of 2022, Part 2. So, friends, in this particular session today, we shall be discussing about some of the very important judgments of 2022. And why are we doing it? This is done to help you, friends, to crack CLAT 2024. So, friends, since we are all preparing for CLAT 2024 now, we are beginning with our preparation. Now, this particular session, we shall be discussing about some of the most important features of some of the judgments that have been delivered by the Honorable Supreme Court of India. So, Ashit Safia, it's that split judgment relating to the hijab case. We are going to discuss that. Then we are going to talk about Ramachandra Bharti, Meenakshi Solar Power, Janhit Abhiyan, the 103rd constitutional amendment providing 10% reservation to the EWS category. Then we shall be talking about Manoj Kumar Tiwari versus Manish Sisodia, wherein we are going to talk about the fact that yes, it is absolutely important insofar as whether a minister can file a defamation case against someone else. And then we shall also be talking about Sukhpal Singh Kharia versus State of Punjab. So these are the 6 judgments that we shall be talking in the course of this session, and this session will be absolutely important for those of you who are preparing not only for CLAT 2024 but also for the exam that is coming in just 2 days time, CLAT 2023 also. Okay, so guys, let's begin. The first important judgment is the split judgment in the hijab case. Now, what is this hijab issue altogether? Now, generally, we have seen from childhood days that, in colleges, there are people who belong to the Muslim community, they wear hijab. Now, the government of Karnataka came up with this particular law wherein it stated very categorically that if you want to enter into the college premises, you cannot wear a hijab. That is what the Karnataka government said. Okay. Now, owing to this, certain writ petitions came to be filed. In the Supreme Court. Okay. So certain writ petitions were filed initially in the High Court. Now the High Court said that the government order is absolutely valid. They are not at all bad. And being disagreed with those order, the Supreme Court heard the petition. Now let me repeat it once again. So the government of Karnataka came up with this particular government order, saying that students belonging to the minority community, who are followers of Islam, cannot wear hijab in colleges. This particular order came to be challenged before the Karnataka High Court. The Karnataka High Court said that the order of the government of Karnataka is valid. Aggrieved by the order, people came to the Supreme Court. Now, what happened in the Supreme Court? There were arguments on both the sides. One party stressed on the fact that your Article 25 rights, right to religion, is violated owing to this government order. And every student has a right to go to colleges. Now, if you are coming with a fact that you cannot enter the college premises wearing a hijab, then your Article 25 right of the Constitution, your fundamental right stands violated. Now, on the other side, the government argued the fact that no, it is nothing. It is India is a secular country. You cannot carry any kind of religious symbol on you. So a person cannot wear a bhagwa, that is that saffron color there. And again, it was also stated very categorically that this is not a violation of any individual's fundamental right. Okay, it is not a fundamental right. Now, owing to this, what happens is very simply this. Okay, now owing to this particular fact, what had happened is this: the Supreme Court of India gave a split verdict. And that verdict was, there were two judges, Justice Sudhanshu Dhulia and the other judge. Now, there were two split verdicts, and the verdict is very simply this. The verdict very categorically states, Justice Hemant Gupta, who says that the government order is valid. What does he say? He says that subject to public order, morality and health, you have right to religion. Now Article 25 categorically deals with the fact that every citizen of this country has a right to preach, profess religion of his choice, practice. Now, what did the High Court say? The High Court said that this particular order stopping women from wearing hijab into colleges is valid. Now, Justice Hemant Gupta of the Supreme Court said that we are in a secular country. Secularism means not carrying your religion inside schools and colleges. Now, for example, in courts, now you are bound to wear coat and pants inside the court premises. When you are arguing, you have to wear a coat and your band, black pants and all, right? So there is a particular uniform in schools, a particular uniform in the army, particular uniform in courts. Now, when uniform comes into being, that is what Justice Hemant Gupta's argument is. He says that there is a prescribed uniform. Now, that uniform is valid under the law. Now, Justice Sudhanshu Dhulia, the judge who dissented, says that this judgment takes away the fundamental right of Muslim women to their religion. Now, if I want to exercise my right to religion, then I will not go to colleges. So, by virtue of this government order, parents would not allow their children to go to colleges. Now, I'll give you an example. Let's take it in a practical sense. The Sikh community, they wear turban. They enter schools, colleges, army, courts. Now, will it be possible for the Supreme Court tomorrow to come to a judgment and say that no, Sikh also cannot wear a turban? No. Now, you have to balance it out. It's high time that the Supreme Court balance it out. There are two arguments. One judge says that you cannot carry your religion inside these premises. The other judge says that if you are doing this, then it creates a havoc. A lot of students, their right to religion will be violated if they have to go to school. And if they don't go to school, their right to education is violated. So, two fundamental rights strikes at the head of each other? Now, before I go through the judgment, BYJU'S exam prep brings to you this test series which consists of 45 mocks, unlimited access to 20 CLAT and non-CLAT mock test, 9,000 practice question, topic covering every subtopic, 3 All India mega mocks and video solutions, detailed mock analysis, and these questions are based on the actual exam pattern. Now, what did Justice Dhulia say? What did Justice Dhulia say? Justice Dhulia very categorically states that the restriction on wearing of hijab in educational institutions like schools, colleges, observes that secularism is a concept applicable to all citizens, and permitting one of the religious community to wear religious symbol of their community would be against secularism. Then the argument is, what about the Sikh community? They wear turbans. Am I clear? This reasoning of Justice Hemant Gupta is on the premise that there are certain dress code. There are certain dress code. Schools, colleges, army. And if you are permitting one religion to wear their religious symbol, that would go against the concept of secularism. Justice Hemant Gupta says, interpretation by the believers of the faith about wearing of headscarf, that is hijab, is the belief or faith of an individual. Religious belief cannot be carried to secular schools maintained out of state fund. It is open to the students to carry their faith in the school which permits them to wear hijab or any mark, maybe tilak, which may be identified to a person holding particular religious belief. But the state is within its jurisdiction to direct that the apparent symbol of religious belief cannot be carried to schools maintained by state from state funds. Thus, the practice of wearing hijab could be restricted by the state in terms of the government order. So that is what I was talking about. So the Justice Hemant Gupta very categorically says that if you are carrying this symbol, it violates secularism. Justice Dhulia differed. He sets aside the judgment of the Karnataka High Court and opined that the ban on hijab is violative of your fundamental right. Article 19(1)(a), 21 of the Constitution, 21(a), that is right to education. What does he say? Schools is a public place. Drawing a parallel between schools and jails and military camp is not correct. Again, if the point which was being made by the High Court was regarding discipline in a school, then that must be accepted. It is necessary to have discipline in school, but discipline not at the cost of freedom, not at the cost of dignity. Asking a pre-university schoolgirl to take off her hijab at the school gate is an invasion on her privacy and dignity. It is violative of the fundamental rights under 19(1)(a) and 21 of the Constitution. Right to her dignity and privacy she carries in her person, even schools at the gate or when she is in her classroom. It is her fundamental right, not a derivative right, which has been described by the High Court. So here Justice Sudhanshu Dhulia says that the moment you are asking a schoolgirl that at the school gates take off the hijab, you are entering into her privacy, her dignity, which is protected under Article 21. Am I clear? Now, there are two different views. In view of this, the matter is placed before the Chief Justice of India for a constitution of an appropriate bench. It has been referred to a larger bench. Okay, A larger bench, a 3-judge bench or a 5-judge bench will be constituted by the Honorable Chief Justice of India relating to this particular issue at hand. Okay. Moving on to the next important judgment. The next important judgment is very crucial. Now, high courts and Supreme Courts are both constitutional courts, right? So you have high courts, we have Supreme Courts, both are constitutional courts. Now, constitutional courts means both the High Court and the Supreme Court has the power to issue writ. Both the High Court and the Supreme Court has the power to issue contempt proceedings. Now, in this particular case, the Supreme Court held that High Court is not a court subordinate to the Supreme Court. Now, in the hierarchy of courts, the judgments of the Supreme Courts are binding on the High Court. Fair thought. Article 141 of the Indian Constitution says that the judgments of the Supreme Court have to be dealt with a lot of respect by the high courts across the country. But that does not mean by any stretch of imagination that high courts are subordinate to the Supreme Court. No, they are not. They are constitutional courts. Both the High Court, now I'll give you an example. Writ petitions can be filed directly in the High Court. They can also be filed directly in the Supreme Court. Both the High Court and the Supreme Court are courts of record. Both the High Court and the Supreme Court are courts of record. Now, so these are all constitutional courts. They are not some subordinate courts or the district courts. Henceforth, the Supreme Court said that under Article 141, High Court is not subordinate to the Supreme Court. However, Supreme Court judgments have to be dealt with respect by the High Court. High Court is not a court subordinate to the Supreme Court. When a High Court deals with judgment of the Supreme Court, which is binding on everyone under Article 141 of the Constitution, it is expected that the judgments have to be dealt with due respect. That is what Justice B.R. Gawai and Justice Vikram Nath had to say about High Court and Supreme Court. Now, what does Article 141 say? The law declared by the Supreme Court, shall be binding on all courts within the territory of India. So, whatever judgments are pronounced by the Supreme Court, whatever judgments, whatever orders, whatever directions are passed by the Supreme Court of India, they are binding on all courts within the territory of India. But that does not mean that the High Court is subordinate to the Supreme Court. No. Is that clear? Very important. A third important judgment. Now, this deals with appointment of arbitrator. Now, I'll just give you a brief idea about what is arbitration. Now, arbitration is one of the out-of-court settlement. Now, whenever there is a dispute, we generally go to the courts. Now, you know the amount of backlog of cases in the courts. Now, especially in commercial dispute, we are talking about 100 crore, 200 crore, 1000 crore matter. Now, when the dispute is of huge money is involved, none of the parties in that dispute want to waste time of the court. And they know that, they will not get a judgment within a week's time or a month's time or within a year's time. They know that, if you go to the court, you waste time. It will take 20 long years to come up with a judgment. So what is this procedure? That is called out-of-court settlement. Now, outside court settlement or alternative dispute resolution, this is called a ADR system, alternative dispute resolution. Now, in arbitration, an arbitrator is appointed. He is like an umpire. He hears both the sides and finally grants an award. It's not called a judgment, it's called an award. An award is pronounced by the arbitrator, and both the parties have to abide by it. Now, in this particular case, the Supreme Court was considering an application for appointment of arbitrator, and the court said that the court cannot get into the question of novation of contract, subsequent change in contract. Now how are arbitrators appointed? Now there is section 30, whatever, there is a particular section of the Indian Arbitration Act which provides that both the parties can appoint an arbitrator. So suppose there are dispute between Mr. A and Mr. B. There's a commercial dispute between A and B. Mr. A appoints Mr. X. Mr. B appoints Mr. Y. And both of them, there are two people, and both of them appoint Mr. Z. So there are three arbitrators, X, Y, Z. This is generally how arbitrators are appointed. So one party appoints one person as his arbitrator, the other party appoints someone else as his arbitrator, then both the two sits and appoint someone else as an arbitrator. So three are there, right? Now this is very, very important for each and every one of you. Why? Now suppose people do not come to a consensus and for appointing an arbitrator, then the Chief Justice of the High Court in a national arbitration, and if it is an international dispute, then the Chief Justice of India appoints an arbitrator. Now arbitrators are appointed by the High Court in national commercial disputes, and if it is an international commercial dispute, the Chief Justice of India has the power. Now, who are these arbitrators? They are former judges, for lawyers, people of great repute who are appointed as arbitrators. Now, over here in this particular situation, it is stated, it was held that during appointment of arbitrator, the court, the High Court, cannot get into the question whether the contract was right, whether the contract was wrong. It is left to the arbitrator to decide. The court should only get into appointment. Let the court appoint an arbitrator, leave it to the arbitrator. The court at the referral stage can interfere only the claims are ex officio, time barred and dead, or when there is no subsisting dispute. As far as the limitation period is concerned, the court noted that issue of limitation period should be referred to the arbitrator tribunal for discussion on merit. Now, during appointment of an arbitrator, the High Courts should only appoint an arbitrator and leave it to the arbitrator to decide. Arbitrator appoint कर दो, उसके बाद आर्बिट्रेटर को डिसाइड करने दो ऑन मेरिट्स. Issue of dispute or defense on the plea of novation or accord and satisfaction should be referred to the arbitration tribunal for determining on merits. हाई कोर्ट को ज्यादा कुछ नहीं करना है, एक आर्बिट्रेटर अपॉइंट कर दो, उसके बाद आर्बिट्रेटर को समझने दो वो क्या मेरिट पे डिसाइड करता है, क्या नहीं करता है. Am I clear? That's very, very important. Am I clear to each and every one of you? Am I clear? Each and every one of you. Okay? Okay. Fantastic. Fantastic. Now, the Supreme Court said that in an earlier judgment, it has been further observed in relation to the aforesaid three categories. The first category of issue, namely whether the party was approached the High Court, whether there is an arbitration agreement, and whether the party who has applied for reference in party to such agreement would be subject to a more thorough examination in comparison to the 6th, 2nd, and the 3rd category. So here the Supreme Court, here the Supreme Court, let's not get into too much technicalities. Here the Supreme Court very categorically said that when a High Court, जब कोई application आता है for the appointment of an arbitrator, the High Court should restrict itself insofar as appointing an arbitrator and let the matters, the merits of the matters be decided by the arbitrator, not anything else. Is that clear? So this was one of the judgments. It's little, let's not get into technicality much right now because you are preparing for CLAT 2024. We will come to these technicalities once you know little more at a later stage. But this judgment is very important. Okay. So we move on to the next important judgment. That is the Janhit Abhiyan judgment. This was relating to the 10% reservation to the EWS. Now, it's a split judgment of 3:2, and the Supreme Court has upheld the 10% reservation for the EWS category. Now, who are this EWS category? Economically weaker section of the society insofar as jobs and higher education is concerned. So the government of India, by way of the 103rd constitutional amendment, the government of India, by virtue of the 103rd constitutional amendment, introduced an EWS quota. Now this EWS quota provides 10% reservations to jobs and in higher education insofar as the economically weaker section of the society is concerned. Now, there are certain very, very important things that have to be taken into mind. Now, there is a very important judgment of the Supreme Court in Indira Sahani, which says that the maximum reservation that can happen is 50%. But if you see over the years, there are many states where you see that the 50% reservation is breached. Okay, it has been breached. Now, owing to this breach of this 50% reservation, is it a violation of the Indira Sahani judgment? So, the 124th Amendment Bill provides 10% reservation, and this 124th Bill, when it was passed, it became the 103rd Constitutional Amendment Act, which provided 10% reservation to the economically weaker section of the society insofar as admission to higher schools and jobs is concerned. Now, this is a particular judgment wherein the Supreme Court says, for the first time, upheld non-inclusion of the backward class. Now, under the EWS is not applicable. EWS quota is not applicable to SCs, STs, SCBCs. Okay, very, very important. So this is for the first time the Supreme Court has upheld a reservation which is not applicable, because 103rd Constitutional Amendment says that EWS quota is only applicable to people who are not covered under SC, ST and STBCs. Okay, socially and educationally backward class. Socially and educationally backward class. Am I clear, all of you? Is that clear? So this is for the first time. Now, we are going to talk about the judgment. Now, the first important thing that was upheld is the fact that reservation for economically weaker section of the citizen up to 10%, in addition to the existing reservation, does not result in violation of the essential features or basic features of the Indian Constitution or the basic structure of the Indian Constitution on account of breach of the ceiling limit of 50%. As I said, Indira Sahani talks about 50%. Now, that 50% has been breached by most of the states. Now, if you go down south in Tamil Nadu, I think there's more than 70% reservation as on today. Madhya Pradesh has very close to around 70, 75, 80% reservation. So, yes, it has been breached, but the Supreme Court is aware of it. The Supreme Court is aware of it because this is something that has to be considered at some later stage by the Supreme Court itself. Now, the Supreme Court said that the 103rd constitutional amendment does not breach the basic structure of the Constitution. It permitted the states to make special provision for reservation on economic criteria. Now, under the Constitution of India, reservation can be done on the basis of backwardness. Now, backwardness means educational backwardness or social backwardness. The term economic backwardness has not been provided under the Constitution of India. Dr. B.R. Ambedkar's Constitution says that reservation can only be done based on social backwardness or educational backwardness. Now, this is for the first time that economic criteria has been used to determine backwardness, permitting the state to make special provisions insofar as admission to private unaided institution is concerned, excluding SCBCs, socially and educationally backward classes, OBCs, other backward classes, SCs, STs from the scope of EWS reservation. Now let's read. Nothing in this article or subclause of this clause shall prevent the state from making special provision for the advancement of educationally weaker section of citizen other than classes mentioned in 4 and 5, SC, STs and all. Special provision for the advancement of any economically weaker section other than the classes mentioned in 4 and 5, insofar as special provisions related to their admission to educational institution, including private educational institution, whether aided or unaided by the state, other than minority education institution. Now, this is subject to a maximum of 10%. So, the maximum reservation that the state can now do for the economically weaker section of the society is maximum 10%. Now, this new clause, okay, this particular clause 6 that was added, this provides that here we are coming, the government says that we are coming with a special provision, a 10% reservation for the weaker section of the society, which cannot be made applicable to STs, OBCs and SCBCs. EWS quota will not be applicable to those who are covered under other reservation. Now, here is what the Supreme Court had to say. Now, Justice U.U. Lalit and Justice Ravinder Bhatt, who dissented, very categorically said that this is for the first time that it's absolutely perfect to come up with a law relating to reservation for weaker section. Nothing wrong about it. It is constitutionally permitted. But the fact that you are excluding the backward classes of people from EWS category, who are excluded, people who are covered under SC, ST, OBC and SCBCs, they cannot apply for EWS quota. This is for the first time in independent India that the backward class is deprived of a particular quota. That is the crux of Justice Lalit's, former Chief Justice of India's argument, and it was a minority opinion. Fair thought. Moving on to the next important judgment, Manoj Kumar Tiwari, Manish Sisodia. The Supreme Court said that ministers, public servant can file public complaint alleging defamation. Now, under the Criminal Procedure Code, persons falling under category, there are certain category, they have to take certain permission to file cases, like ministers. Now, what does this say? I'll just tell you. Special procedure is given to people for filing complaint. Now, if you are a public servant, there is section 237 of the code to the accused. Now, public servant needs to get a permission to file a complaint individually. There is a special provision. Now, the Supreme Court says that this is not the right thing. When a person is prosecuted by a public servant in his individual capacity, he can always fall back upon section 250 for claiming compensation on the ground that the accusation was made without reasonable cause. Very good. Now, I'll tell you. Now, what was stated? Now, both the two people, Manish Sisodia and Manoj Kumar Tiwari, they are all politicians in Delhi. Now, one person tells to the other person that I will expose your corrupt practice, I will expose you in a tweet. Now, can that be presumed as defamation? That's a simple question. Now, suppose one minister tweets that, to another minister that, I am going to expose your corrupt practice. I will expose you. I will expose your scams. Now, over here, the Supreme Court says that this kind of thing happens. And this does not amount to defamation. This fact, there is no intention to harm the reputation of the person holding office. Statement that I am going to expose you, I will expose your corrupt practice, I will expose your scams in which you are involved, are not themselves defamatory unless there is something more. The same cannot amount to defamation. Is that clear? Is that clear? Am I clear? Tell me. Okay. The Supreme Court said that defamatory statement should be specific and not vague and general. The essence of section 499 is that the imputation must made by the accused should have the potential to harm the reputation of the person against whom the imputation is made. Very important. To say that the provision of subsection 6 of 199 can be invoked by individual public servant only in a case where the state government does not go to his rescue would violate the plain language of the subsection. Now, in a later time, when we talk about defamation, when we learn, since you guys are all preparing for CLAT 2024, we will have a number of sessions. I'm going to explain to you what is this judgment, how does it has repercussions on defamation suits filed by public servant. Okay, this will become a little technical for you right now. We will talk about this later. Okay. Chalo. I'll talk about this later. Okay. This is important judgment, but yeah, I'll tell you this. When any offense, okay, is alleged to have been committed against a person who, at the time of the commission, is the President of India, Vice President, Governor of the state, Administrator of Union Territory, Minister, public servant, employed in connection with the union or the state in respect of his conduct in discharge of his public function, a court of session may take cognizance of such offense without the case being committed to it, upon a complaint in writing made by the public prosecutor. So, unless the public prosecutor writes, the court cannot take cognizance of such a case. Every complaint set forth which constitutes the offense alleged, the nature of such offense and such other particular as are reasonably sufficient to give notice to the accused. So, state government in the case of a person who has been governor of a state, minister of that government. So, a permission is required to be obtained from the state government if you have to prosecute a minister. Is that clear? Is that clear? Same thing with the central government. So no court of session shall take cognizance of an offense unless the complaint is made within 6 months from the date when it has been committed. Nothing in the subsection shall affect the right of a person against whom the offense is allegedly to have been committed to make the complaint in respect of the offense before the magistrate, having jurisdiction of such powers to take cognizance of that complaint. So, if you want to file a complaint against a minister, a public servant, you have to take permission. So, that has been stated. Okay. Then over here we have another very important judgment, and I will for this judgment will take a lot of time. This is I think it's given around last week, a constitution bench judgment of the Supreme Court, which was dealing with the ambit of power under section 319 of CRPC. It's a constitution bench judgment of the Supreme Court. Now, what are the questions? I'll just read it because you guys are preparing for CLAT 2024. You must have a lot of idea before you understand this. The question was whether the trial court has a power under section 319 of CRPC for summoning additional accused when the trial with respect of other co-accused has ended and the judgment of the conviction rendered on the same date pronouncing such summoning order. So, suppose there are 50 accused. 40 accused have been given a judgment that they have been set free. Okay. Now, for the rest 10 accused, after the first judgment, can the court ask for additional summoning of co-accused? The Supreme Court says, no, you cannot do it. The Supreme Court has laid certain guidelines relating to the power of summoning of co-accused when the case is pending. The Supreme Court has given a particular guideline as to how things are to be done. Okay, so whether the trial court has the power under section 319 for summoning additional accused when the trial with respect of other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order. Before moving ahead, BYJU'S exam prep brings to you a 7-day mega revise series schedule. Revision ka extra dose. Do watch our YouTube channel for this. This is a particular judgment. I think I'm going to have a separate session on this particular judgment because this is a very lengthy judgment. It's a constitution bench judgment. And right now, I don't think it's the right time for you to understand this particular judgment because you need a lot of prior knowledge of criminal law. Okay, I'll just go through the judgment. The power under section 319 of CRPC is to be invoked and exercised before the pronouncement of the order of sentence when there is a judgment of conviction of the accused. In the case of acquittal, the power should be exercised before the order of acquittal. Hence, the summoning order has to precede the conclusion of the trial by imposition of sentence in the case of conviction. in the order is passed on the same day, if the order is passed on the same day, it will have to be examined on the facts and circumstances of each case. And if such summoning order is passed, either after the order of acquittal or imposing sentence in the case, the same would not be sustainable. Very important. So there are a number of questions that the Supreme Court relied. Okay. The Supreme Court said that the trial court has the power to summon additional accused. But there is a but. The but is you have to summon the other accused before you give the judgment. After judgment, how can you summon the co-accused? Either he is let free or he is convicted. Now, what is the use of extending a trial after a judgment is given? So that is what, and we'll have a proper class. इसके ऊपर एक proper class होना चाहिए क्योंकि ये इतना easy नहीं है. What are the guidelines that the contempt court must follow while exercising power under 319? The Supreme Court has also given a number of guidelines. Any other person is committing the offense based on evidence recorded at any stage in the trial before passing of the order or acquittal or sentence, it shall pause the stage of trial. ये तो pause हो जाता है. The court shall thereupon first decide the need or otherwise to summon the additional accused and pass orders thereon. So how should that procedure be followed? That has to be taken into consideration. Final race to CLAT, join 7 days revision session at 7 and 9 p.m. Okay. Now we will have a proper class on this particular issue because it is a constitution bench judgment. And yeah, it's a very important judgment. It has been just given last week itself. Just last week, I think this week itself, around 2 days back. So we have to understand the judgment. I'm going to explain to you the judgment. It's a very, very important judgment relating to how to summon co-accused. Okay. Now, BYJU'S exam prep on 18th of December. As you know, there is CLAT 2023. There will be a detailed analysis of the CLAT question paper on 18th December. Section-wise analysis, expected cutoff, memory-based questions, and good attempts. Do subscribe and press the bell icon. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S Exam Prep Live. Do like this session and share this session with your friends. We shall have more of these kind of sessions coming very soon. Thank you very much. God bless you. Thank you.